Item 3.1, consideration of an amendment to Chico Municipal Code Section 944-015 relating to sitting on sidewalks in commercial districts. Report from Mr. Ewing, our city attorney. Mr. Ewing.
Thank you, Mayor Morgan, members of the council. This is an introduction and first reading of an ordinance relating to the amendment of Chico Municipal Code Section 9.44015, sitting on sidewalks in commercial districts. It's recommended that the city council adopt an ordinance amending Chico Municipal Code Section 9.44.015, ordinance of the City Council of the City of Chico amending 9.44.015 of Title 9, Division 6, Chapter 9.44 of the Chico Municipal Code. It's set forth in Attachment A. On November 19, 2013, the City Council approved Ordinance 2445, which added Chico Municipal Code Section 9.44.015, prohibiting the sitting or lying on sidewalks abutting commercial properties throughout the city between the hours of 7 a.m. and 11 p.m. The ordinance had an expiration date of January 1st, 2016, and has since ceased being enforced. To enforce CMC Section 9.44.015, an amendment is necessary to reinstate the section by removing the expiration date. On September 4th, 2018, the Chico Police Department reported to the City Council that Section 9.44.015 was enforced from December 19, 2013 to January 1st, 2016. And during that time period, the following enforcement statistics were developed. 221 people received verbal warnings, a total of 247 verbal warnings, and 39 people received a total of 56 citations under the ordinance. Chico PD recently reported that during the period of enforcement, deterred individuals from obstructing the rights of way and reduced panhandling and harassment of business patrons in the downtown area of the city. Chico PD further reported that the concerns giving rise to the ordinance continue to exist and therefore recommended the City Council reinstate CMC Section 9.44.015 to address such continued concerns. On September 4th, 2018, the Council directed the City Attorney's Office to review the city's sitting and lying regulations in light of the Ninth Circuit Court of Appeals decision, Martin et al. Versus City of Boise. On September 4th, 2018, the United States Ninth Circuit Court of Appeal ruled that the disorderly conduct ordinance adopted by the City of Boise, Idaho, violated the United States Constitution by imposing criminal sanctions against individuals sleeping outdoors with minimal protection from the elements. For example, a blanket, while on public property when no alternative shelter is available to them. In the Martin decision held that such an ordinance was a violation of the Eighth Amendment constitutional prohibition against cruel and unusual punishment. The Martin decision now stands as a bar against a citywide ban on sleeping at all times of the day or night, so long as there is a greater number of homeless individuals in the city than the number of available beds and shelters. Therefore, until a city can show that there are sufficient shelter opportunities, beds in a shelter, for homeless persons, the enforcement of ordinances prohibiting all sleeping outdoors, that is a complete ban citywide at all hours, will likely be deemed unconstitutional under the Martin decision. The Martin decision was clear in its holding that it did not prohibit more limited restrictions regarding obstructing the public right-of-way or restrictions limited in scope to specific areas. While the criminalization of sleeping outside with elementary bedding where no alternative shelter exists is prohibited after the Martin decision, the court's ruling also provided clarification that a city may continue enforcing ordinances based on time, place, and manner restrictions which prohibit sitting, lying, or sleeping outside at particular times or in particular locations, as well as ordinances barring the obstruction of public rights of way or the erection of certain structures. The proposed ordinance before you is not as broad as the disorderly conduct ordinance in the Martin decision that was deemed inconsistent with the Eighth Amendment. The proposed ordinance is limited in time and place of enforcement. It prohibits a person from sitting or lying down upon a public sidewalk, curb, or street, upon a blanket, stool, chair, or other object placed upon a public sidewalk, curb, or street, which is adjacent to any property zoned or used for commercial uses. It's limited in time of enforcement to between the hours of 7 a.m. and 11 p.m. Persons violating this ordinance shall be guilty of an infraction and upon conviction are punished by fines. In comparison, the disorderly conduct ordinance in the Martin decision criminalized occupying, lodging, or sleeping in any building, structure, or place, whether public or private, without permission at any time of the day. As mentioned, conversely, the proposed ordinance prohibits sitting, lying at particular times, 7 a.m. to 11 p.m., in particular locations, public sidewalks, curbs, streets, which are adjacent to any property zoned for commercial uses. Further, the proposed ordinance is consistent with the Eighth Amendment as it does not punish a person lacking the means to live out the universal and unavoidable act of sleeping by preventing such act anywhere in the city at all times of the day. The proposed ordinance prohibits obstruction of entrances to buildings to ensure the free and safe flow of pedestrian traffic around the buildings, in the buildings, and businesses. Further, the court in the Martin decision stated as follows: even where shelter is unavailable, an ordinance prohibiting sitting, lying, or sleeping outside at particular times or in particular locations might well be constitutionally permissible. The proposed ordinance prohibits sitting and lying at particular times and in particular locations, just as the court states may be permissible under the Eighth Amendment. Therefore, the city may choose to reinstate enforcing Chico Municipal Code Section 9.44.015 following the Martin decision. This concludes my report. I'm available for questions.
Thank you, Mr. Ewing. Questions for the city attorney or other staff members from council? Mr. Ory.
What's the cost of an infraction?
$100. That's the proposed fine. Often what happens is you can, if it makes its way to court, sometimes the fine can be reduced and so forth, but on the books it's $100.
And what's the consequences of somebody not showing up or paying the fine?
So the initial consequence for one failure to appear would be a warrant would be issued, a failure to appear warrant would be issued, and that FTA would be would go into the system, and then that person, if they're contacted again, the FTA, or the failure to appear warrant, would show at that contact, and that person might be arrested or might be told, hey, by the way, you have an FTA, you should probably show up to court next time. However, this is, each case is a case-by-case specific fact circumstance analysis. So that's generally how it goes.
So an infraction could easily become a criminal event.
It could be.
Do we know of the citations that were issued? How many of them went to failure to appear and became criminal events?
I do not have that statistical information. Perhaps the chief is aware.
Thank you.
Other questions, comments? Ms. Scwabb.
I just wanted to clarify the scope of this ordinance, that it is for all commercial areas within the city of Chico, not just a specific downtown area or west of the Esplanade or east of the Esplanade. It's for all commercial properties.
That's correct. It's not geographically limited in the as you described. It is limited by the zoning. So it's commercially zoned areas within the city. And of course, that zoning is based on geography.
Because originally, I believe we had an ordinance that was limited in scope to the downtown area. Or maybe it was conceived as such. And then some of the discussion was, since it was citywide, we saw, or no, if it was downtown only, then we saw a lot of disbursement.
I'm not saying yes, that's what it was, but that's kind of what I remember, because I remember you recusing yourself the first time. Yeah. Okay, further questions for staff? I will ask one of the police chief. Normally I let him know I'm going to ask him a question. Chief, this is a tool you are interested in having.
It is, Mayor. As you can see, that we use this judiciously. We always are careful with our use of ordinances. In this case, a vast majority of individuals were given warnings, not cited. And really, if they would comply, if those individuals comply with the direction of the police officer that this is a violation, no one would be cited. It's only for those instances where that compliance was not met and those citations were issued. But as you can see, it was for a very limited number of individuals.
Okay, and to be clear, I mean, we're not talking about someone taking a nap in City Plaza on the grass. We're talking about someone willingly lying across the sidewalk in front of a business during mostly business hours.
Correct. That's correct.